the two of them, once rent started to be paying late, were acting in bad faith. In December of 2024, Amanda Conway let me know that Mr. Ferguson had been laid off a month earlier. I asked for proof of this so I could help them by stopping any late fees. If they lost their job, I was trying to do show a gesture of goodwill by stopping late fees. And the proof that was sent was actually a termination notice, and instead of a loss of position. You can see that termination notice in Exhibit G. And I believe that this misrepresentation may have been intended to avoid payments by inducing sympathy from myself. Anytime rent was late, I communicated regularly with Mr. Ferguson and Ms. Conway via text messages, which are in Exhibits E and F. Of course, I waived late fees once that happened. Once I got that termination notice, even though I didn't necessarily believe that he had actually been laid off and was actually terminated, I still waived the late fees. Also offered a payment plan in good faith, which is Exhibit J, which he did not follow through on. The court cost for this, so we respectfully request reimbursement for the cost of $163.71, in addition to the amount stated previously in the court filing fees that supported by Exhibit K. And lastly, I'll wrap up here. Your Honor, we followed the lease terms, we provided proper notice, we documented all charges and communications, and attempted resolution outside of the court. I believe, however, that Mr. Ferguson and Ms. Conway did not communicate honestly and acted in bad faith to skirt their responsibilities. On more than one occasion, they let me know they'd catch up on their rent by a specific date. They never met the deadlines they gave themselves. They also let me know they were building a house and would move out in March of 2025 when it was complete. At the end of February of 2025, they let me know there was no house being built. This was suspicious to me again and reinforced that they weren't being honest. And additionally, after move out and receiving their forwarding address, I contacted the property manager who manages 712 Fairway, and he let me know there was no one by Michael Ferguson or Amanda Conway listed on the lease, and it leads me to believe that's just another pattern of dishonesty. And I say this not bringing up to punish him personally. There's nothing personal. It's only to show a pattern of dishonesty. And aside from collecting the amount owed, a goal is to create a legal record. A goal of ours is to create a legal record and protect other landlords from the dishonesty. In Mr. Ferguson's response to the claim I filed, they mentioned that I submitted the deposit form late to them, past the 30 days. And Your Honor, I misunderstood the law. I believed I had 60 days instead of the 30 days to return it to them. And once I realized my mistake, I acted quickly after hours. In fact, it was between the hours of 8 and 9 p.m. And the forwarding address was not provided until March 6th. And I sent the itemized list on April 10th. There was no intent to act in bad faith, an honest mistake on that part. Your Honor, Mr. Ferguson is also going to bring up a text message about forwarding mail.
Well, let's do this, Mr. Alford. Don't assume what he's going to bring up. When he does bring something up, you're going to have a rebuttal to him. Let's do it at that time. Okay.
Fair enough. Yes, sir.
Thank you. All right. Do you have an itemized list of the damages that you're seeking?
Yes, sir. That is Exhibit I.
Okay. And Mr. Ferguson, do you have Exhibit I? Or do you have any? I just want to make sure you have it.
Yes, sir, I do.
Okay. All right. Okay. All right. Mr. Alford, do you have anything
Yes,
else?
sir.
And you'll have rebuttal after this is
Yes, sir.
after Mr. Ferguson gets through, you'll be able to do a rebuttal as well. Okay.
Yes, sir. I believe that's all for me for now.
All right. Mr. Ferguson, you've heard everything that's been presented so far. Do you have any questions of Mr. Alford of anything that he presented to court?
No, I believe everything's correct, other than acting in bad faith. I didn't think we were coming here to smear people, but we'll go through this.
No, we're not coming here to smear people, and that's what sometimes people say things, but it's irrelevant. Basically, we're here for damages in the amount stated by Mr. Alford. So I'm just giving you the opportunity to ask him any questions if you had any questions about that.
No, I do not.
Okay, Ms. Ferguson, do you have anything to say in your defense?
I've got a few things to say. Some of the reasoning for some of the actions that were taken are we kept asking, and we set up a payment plan. Yes, I agree. I agree to the money owed. I'm not denying that. We agreed to every bit of that. But we kept asking him prior to the payment plan, we need a list of the itemized damages or our deposit. What part of that's being credited back to us? We cleaned everything as good as we could. I mean, we didn't paint, of course not. I didn't know that was part of our lease agreement to repaint the house, because when we moved in, it was not painted. The cleanup in the backyard, there was bushes all over the backyard. They have a kennel, big kennel in the back that you couldn't even get into. But I'm not denying the rent that's owed. But the only thing I'm arguing is the amount of the repairs, and also the timeline of, we kept asking, send us this, and we never got it. Some of the text messages were, I don't really want to go there, but since he wanted to go there, he did. There is a text message where he stated that he would throw our mail in the trash. Anything that came there would be thrown in the trash. And that's not something that should have happened. Forwarding address, we did give him address because we were in between places at the time, and that is her son's house. They did rent that, and so we figured that'd be the easiest way for him to contact us. And that's pretty much all I have to say. I just don't agree with the amount of the repairs. And I agree with the rent, yes. But I wasn't going to keep paying his payment plan without an itemized list of, quote, damages. We kept asking and we weren't getting it.
Okay.
That's all I have to say.
Okay.
No,
Mr. Alford, do you have any questions of Mr. Ferguson?
Not necessarily questions, but a rebuttal.
No, just specific to what he presented to court, and then you're going to have an opportunity to give another rebuttal if you wish.
No, I don't believe I have any questions.
Okay. Do you have anything further to add?
Yes, sir. As far as the throwing away in the trash, my specific text, which I provided the court myself, says that any mail will be disposed of. I will say here under oath on record, I never disposed of any mail. And I actually apologized to them later for saying that out of frustration. Never disposed of any mail. Actually, that day sent one more, wrote a note in the mailbox, and the mail carrier the very next day marked it as vacant. So I was clear in that communication part of it. I also, anytime packages were delivered from third party besides the USPS, whether FedEx, UPS, whoever, I notified them even as late as May 19th after this file was claimed. So I sent all their mail to them and never disposed of any mail.
Okay. Anything else, Mr. Alford?
The number of times that they asked was, I'd have to go back and look in my text messages real quick. Asked for the itemized list. Was, I would say, up to 3 times. And to be honest, with the amount of work that needed to be done, it took longer, and my misunderstanding of the law, which I also have admitted to and let them know that was an honest mistake. But they got it. It should have been received by April 5th, and they got it April 10th. Again, I worked, as soon as I realized my mistake, I worked after hours to make that happen.
Okay, and that would be a separate issue other than this. Okay. Anything else, Mr. Alford?
I just want to reiterate again, there's nothing personal in this hearing from my side. My goal is to recoup. The first goal is to recoup the amount owed, and second goal is to prevent this from happening to other landlords in the future.
All right. Anything else?
No, sir.
Okay. Ms. Ferguson, any questions of Mr. Alford of anything that he just presented?
No.
Okay. All right then. All right then, gentlemen. Having heard the evidence, of course, you have a lease and everything's pretty much covered in the lease. I know there's a little controversy about what is due, but the court feels that the plaintiff has satisfied his case, and the court finds for the plaintiff for the judgment amount of $4,322.84. The court will also award the plaintiff the court cost in the amount of $161.63. This is the judgment of this court. Mr. Ferguson, I want you to understand that you always retain a right to an appeal. However, you have 22 days to appeal the decision of this court. If you wish to do so, you must post a cash bond for twice the amount of the judgment to this court, and then it'll be transferred upstairs to the next court, which is a county court at law. Understand that if you do appeal, it will be de novo, which means from the beginning. So for both parties, Mr. Alford, you've presented a lot of evidence to this court, but you have all that because if he does appeal, you will need it for the next court as well. Okay?
Yes, sir.
All right. Gentlemen, thank you very much. Like I said, the judgments will go out in the mail today. You should get them in your mailbox today, tomorrow, or the next day. All right?
Right.
Thanks, sir.
Thank you.
All right. Thank you both. We are adjourned.
All right. Bye-bye.
Thank you.
Thank you.